Welcome to SQE1 window. We explore company members in our chapter 4 today. So, company members, now if you have ever wondered who actually owns the company and what powers they yield, this is the slide for you. You need to understand who are they and how they work. A member of a company is essentially a shareholder, a person who owns shares in a limited company. Shares are interesting creatures. Not only do they represent a financial stake, but they also create a contractual relationship between all shareholders. Yes, owning a share isn't just about money, it's a promise to play nicely with the other members. Remember the famous case of Borland Trustees versus Steele 1901? Shares are defined not just as money, but as mutual covenant between shareholders. This means your right and obligation come backed in with your shareholding, like Marmite, like you either understand it or you don't. So there are different classes of shares. We need to understand share come in different flavors: ordinary, preference, redeemable, and cumulative preference. Ordinary shares are your everyday cup of tea that you buy online from different companies, or you can have it in a private company as well. They give you voting rights and dividend, but nothing fancy. Preference share are a step up, and it's a deluxe brew. They get paid dividend first. If there is a profit, they get their chunk first, which is attractive. If you prefer, certainly over thrill, redeemable shares can be bought back by the company later on. Kind of loan, giving them flexibility as well, like, the people who have just invested. And cumulative preference shares are the overachievers. If a dividend is missed, it accumulates, yes, it is like interest on your leftover cake. So understanding these classes is vital for SQE1. A scenario question might ask which shareholder gets paid first. So keep these straight in your mind. Just tidy up. So the next thing is like the contract of membership, the statutory contract of membership under Section 33 of Companies Act 2006 is like the invisible glue binding the members to the company and to each other, of course. This means three things like you need to keep in mind. The company can enforce the constitution against members. Members can enforce it against the company, and members can enforce it against each other as well. Imagine a shareholder trying to sell their share outside the agreed preemption right. Section 33 allows other members of or the company to intervene. Remember, SQE loves testing scenarios where someone breaches these rights. So picture it clearly in your mind. So, what are rights of members and shareholders? Members enjoy several fundamental rights. You get notice of meeting, so you can show up and look important in the meeting. You can attend and vote either in person or via proxy. You can transfer your shares and you can check annual accounts, receive dividends, and get a share of proceed if the company winds up. So for SQE1, so remember the core right: voting, dividend, information, and distribution. Don't get tripped by the fancy word in question. Always tie them back to what the shareholder can actually do. So dividends are like, once again, let's go back to that one. Like, dividends are the sweet reward for shareholders. Once there is a profit in company, they get their chunk out of it. So there is another thing, another concept that is tested in SQE. So that is uh, persons with substantial control. So every company must maintain a register of its member detailing who owns what, when they joined, and how much they paid. Private companies can even choose to keep this at company house, making membership info for the public, like open to public. Additionally, there is PSC register. So people with substantial, I call it most of the time, I forgot, it's significant control, who got significant control on the company. So anyone who owns more than 25% of the share or voting rights, or who can remove the board, like directors from the board. So at that point, they count as persons with significant control. Update must be made promptly on the registers, like, people who are controlling the company. SQE type exam question often tests your knowledge of registers and what must be recorded. Make a mental checklist. Members, PSC, date, share class, and paid amount. That's what you need to keep in mind once you are in SQE. So what are company meetings? That's a forum where they decide, most of the matters about company. So it is company governance that involves two types of meetings: annual general meetings and general meetings. The annual general meetings are the classic accounts direct. In that case, like, they present accounts, directors are there, auditors, and dividends. So private companies incorporated after 2007 may skip annual general meeting unless the articles say otherwise, if they have just adopted in their articles. Notice period are critical: 14 days for general meeting, 21 for annual general meeting, and short notice is possible with high consent level, and that's 90% of the votes. Voting can happen on a show of hand, or by poll, or by written resolution. Remember the dogmatic principle. Unanimous agreement can replace formal meeting. Handy for cozy private companies, but don't rely on it for exam question. It might come with a trick scenario at that point. So trick or treat. So you should keep in mind. So show of hand, polls, or written, and proxies as well. Not the person himself. They appoint someone to just go and vote for it. So protection for minority. There can be majority shareholders and minorities can be there, like a person poor who got 1% of the company, not 1% of the Amazon, will not be a poor person. So minority shareholders are vulnerable and the law recognizes this. There are several protection for them, like Section 33, enforcement of membership rights. Then shareholders agreement, which can be enforced under Russell v. Northern Bank. Derivative claim to pursue wrongs on behalf of the company, that they don't do it on themselves, they do it on behalf of the company if things have gone wrong. Unfair prejudice, petitions they can file. So that's most common, that this action will impact my share in the company. And finally, just and equitable winding up, the nuclear option, just blow it up. Let's give me one love scenario question where a minority shareholder feels oppressed. Think of the remedies as a ladder. Try to lighter option first. Winding up is always at the last. Like, you don't straight away jump that they can go and wind up the company. So in summary, to recap, in this chapter, we covered members, share classes, statutory contracts, rights, dividends, registers, meeting resolutions, and minority protection, all about corporate governance. So key exam things that you need to keep in mind: rights flow from share class and statutory provisions. Meetings and resolution have strict formalities, and minority protection mechanism exists to prevent abuse by majority. Keep this structure in mind. It's like your roadmap through your SQE questions. So once again, we come back to common pitfalls and tips. So in tips, focus on rights under Section 33, share types, and meeting procedures. Ordinary versus preference versus redeemable versus cumulative shares. You need to understand what are they. So register of members and persons with significant control. Know the details that must be recorded. Voting can be done by show of hand, polls, proxies, and written resolutions. Minority protection comes from unfair prejudice, derivative claim, just and equitable winding up. So common pitfalls are: people mix up rights, ignoring quorum and notice rules, forgetting liability for unlawful distributions, and assuming all decision can be written resolution. Not at all. So practical tip: just use scenario questions to test your understanding, and we got a bank of it for you. Thank you very much for being with us today. Ta-da!